Okay. Hi everyone. I think we are ready now, and please turn on the camera because we are going to live now.
Okay.
Yeah, thank you.
Thank you.
Pardon? Okay.
Tên được không đấyครับจะเริ่มแล้วเหรอแป๊บนึงนะคุณว่ารอสักครู่แต่เขาไม่ได้ยินโอเค Okay, should we start this online seminar now? Welcome our distinguished guests. You are watching the live broadcast from the webinar on the topic of time to fight against SLAPP in Southeast Asia through Facebook page of Prince of University Faculty of Law. The discussion will take place about 2 hours. There will be simultaneous interpretation in both Thai and English language. So in case you would like to join Thai language, you can go to the page and there will be a link that you can join the channel of Thai language. There will be Thai language in that channel. So today we will discuss mainly about SLAPPs, which is stand for Strategic Lawsuits Against Public Participation. And there will be 3 sessions today. First, with the opening remarks with Assistant Professor Sutichai Ngam Chin Suwan as a Dean of Faculty of Law, Prince of University. Following the opening remarks, we will have a short concept of the SLAPP law. Then we will have 4 keynote speakers, which are, the first one is Kun Sanhawan Sisot. She is a legal advisor in International Commission of Jurists, Thailand. And Mr. Edmund Bon Thai Soon. He is a head of Chamber Civil Amerbon for Malaysia. And then Mr. Reynaldo Sembring, a public lawyer, the Regional Council of Wauhai, DKI Jakarta, and then the representative from the Philippines. So the issues will be divided into 2 rounds. Each round for each speaker will be approximately 15 minutes. For the first round, we will share about pattern of SLAPPs in each country, in Thailand, in Indonesia, Philippines, and Malaysia, and tools to fight back against the SLAPP suit in each country. And for the second round, we will discuss what legal reforms do we need to further improve protection against SLAPPs. So we will have 2 rounds, each round about 15 minutes per person. So I would like to invite Assistant Professor Suthichai Ngam Dean of Faculty of Law, Prince of Songkhla University, to welcome our speakers and participants to this seminar. Thank you.
Good afternoon, everyone. As the Dean of Faculty of Law, Prince of Songkhla University, I am pleased to welcome you to this virtual seminar. To celebrate International Human Rights Day, the Faculty of Law, Prince of Songkhla University, and our contributing partners are hosting a regional online forum titled Time to Fight Against SLAPP in Southeast Asia. The forum will look at how each country handles SLAPP and the underlying concern with the goal of eliminating this type of judicial harassment. The term strategic lawsuits against public participation of SLAPP refer to the technique of using judicial procedure to threaten or silence individuals, groups of individuals, or other entities that exercise constitutionally guaranteed freedom and right to protect public interest or concerns. In Southeast Asia, only Thailand, Indonesia, and the Philippines have anti-SLAPP legislation. Nonetheless, numerous experts expressed concern that these regulations were insufficient to protect against harassment through the judicial system. To help us address this concern, we are honored to be joined today by distinguished speakers from 4 ASEAN member countries, Thailand, Malaysia, the Philippines, and Indonesia, as Assistant Professor Suren mentioned before. Many thanks to all honorable speakers for participating in this forum. I hope that this discussion will provide an opportunity for us to learn from one another and share our experience in the battle against SLAPP lawsuits that undermine democratic society. So I wish you all enjoy this webinar. Thank you.
Thank you very much, Assistant Professor Suthichai Ngam. Next, I will go to the session, the first session. I would like to invite Kun San Hawan Sisot, Legal Advisor, International Commission of Jurists, to chair the pattern of SLAPP in Thailand and the tools to fight back against the SLAPP suit, please.
Thank you very much. So I would like to share my slide here. Okay, so you can see the slide, right?
Yes.
Okay. So my section will be about SLAPP in Thailand. So for those who are not familiar with this topic, I understand that there will be a lot of students who are gonna watch this. So as a background, SLAPP is lawsuit that undertaken with principal objective of curtailing public criticism or opposition to certain activities of the entity who initiating that legal actions. So basically, it is the misuse of judicial process, justice sectors, and justice process is used as a tool to silencing people, to silencing someone, to stopping them from doing activities that the one who initiate the legal action doesn't want them to. So when it comes to SLAPP lawsuit, the plaintiff not always expect to win the lawsuit. Their goal is just to burden the defendant with litigation fee, contribute to their fear or exhaustions, to the point that the defendant might just abandon the criticisms or the activity that is the subject of the cases. So to make it easier to understand, as every individuals, you have your freedom of opinion and expression, freedom of peaceful assembly, freedom of expression, right to take part in conduct of public affair. When it comes to some public issue, you can criticize it. If your rights are violated, you can tolerate. That's a principle. However, there could be someone, it could be business entities, it could be a state government or any individuals who want to silence you, who want to force you to stop talking about it. So what they did is just to bring the case to court. They sue you, so you're under a lot of burden to go through the judicial process, and then you stop speaking about it. So when it comes to SLAPP practice in Thailand, indeed, it's just not in Thailand. I would say that there's a group of people who are the typical targets for SLAPP, not just in Thailand, it's almost in every country. And this includes journalists, civil society activists, academic, human rights defenders, political activists, workers, union members, or government critics. These kind of people are the typical targets who always got slapped. When they start talking or criticizing about certain issues. In Thailand, slap happen both like online or offline platforms. Like when people express themselves, whether it's online or offline, they could be subject to certain type of litigations or lawsuit. The one who initiate the legal action in Thailand could be they're all like there are some cases were initiated by state authorities, some were initiated by business enterprise, and some were initiated by just certain like some group of individuals. The very interesting thing about Thailand is that many slap cases are criminal cases. I would say like probably 70% or something, 80% of slap cases are criminal cases. And the very unique thing about Thailand is that when it comes to criminal cases, there are two ways to bring the case to court. First one is that the plaintiff may just go to court and bring the case directly and ask the court to look into the case. Another way is to file the complaints with the police. So the police will be the one who initiate the case, and then it will go to public prosecutors, and then it will go to criminal court. Slap happened both ways. Some cases were submitted directly to court, and some cases went through the police channel. So in Thailand, there's both type of slap in criminal cases. Another interesting about the slap case in Thailand is that we have a lot of slap cases against those who express themselves online. And when it comes to online related case in Thailand, people can submit their complaints with police in every provinces. So basically, if you talk, for example, your home is in Bangkok, and then you talk in Bangkok, but you express yourself via your smartphone, using your smartphone, and post something on Facebook, there could be people from the South Thailand, like in Songkhla, who just go to the police and sue you, and because you are typing it, online, and they don't care that you are in Bangkok. So you have to go all the way to report yourself to the police in Songkhla province, and it can take you, if you drive to Songkhla, it will take you like 10 hours to go there. Many slap cases in Thailand, it end up being dismissed or withdrawn by judges. But this happened after years of litigation, at least 2 years, and there are some cases that took like 5, 7, or 9 years until the judge dismissed the case. Otherwise, the plaintiff also withdrawn some slap cases in Thailand, but came after several rounds of negotiations, and they reached a settlement. And this settlement normally include a clause requiring one to refrain from discussing the topic or conducting activity that is the subject of slap cases in the future. So, of course, they withdrawn the case. You are not sued. However, you need to comply with the settlement conditions. We need to stop talking about it. In Thailand, the very popular laws that are used for slap is for criminal prosecution. We have criminal defamation law, we have criminal code provisions. The very famous one is like 112 lese majesty law. We have sedition life offense 116, or criminal trespassing in environmental related case. We have Computer Crime Act, Contempt of the Court, Public Assembly Act, or emergency decree that are supposed to use to control the pandemic, but it's used more to arrest those who criticize or sometimes came out to protest against the government. I'll give you an example later. There's also civil lawsuit in Thailand, and they use like tort law, civil defamation law, or contempt of the court under the civil code. I have to say that many of these laws, I would say most of these laws, indeed, they are non-human rights complaints law. That means the way they are drafted, the way they stand, is not compliant with international law and standards. So the text themselves is not human right friendly, and then they are also misused by the authority in a non-human right friendly way. So you have like a lot of problem with that. Just a bit on the statistic. In Thailand, between 1997 and 2020, first UNDP documented at least 96 slap cases, 71 criminal cases, and 25 civil cases. However, these are only cases that were brought by business enterprise. We didn't count in the case that brought by state authorities, and there would be a lot more, but because there are so many cases, so now it's pretty difficult to document it here. And just to give an example of case that brought by business enterprise, slap case that brought by business enterprise, there are cases that between a poultry farm company in Thailand and those who speaking out against them on their labor practice. So those people who came out and speaking out about their alleged exploitative labor practice were charged with mainly criminal defamations. There are now at least 21 cases, 19 criminal cases, and 2 civil cases. And case was brought against the former employees of the companies, journalists, human rights defender, and even National Human Rights Commissioner. Talk about this case because this case was brought into the attention of the United Nations, and the UN expert also made a statement about this case, and they're calling that the practice, like such as in this case, the case of the poultry farm company, they consider it as a slap cases. Another example is the case that brought by state authorities in Thailand. Indeed, this just happened a few days ago in Thailand. There's a protester who opposed an industrial complex. And they protest at the front of the government house, demanding the government to suspend the project in their hometown. Basically, but they were arrested for violating degree traffic law and disobedience to the authorities for protesting. And 37 protesters were arrested, and this includes 31 women and 6 men. But this is how you see it, because in the process, when they were arrested, the police proposed to them that they won't press any charge against these people if they stop protesting and stop criticizing about this project. So you see, this is how slap works. The victim could be charged if they continue talking about it, but if they stop talking about it, then probably they're going to be settlement. People will stop charging or suing them. So that's how the pattern. I'm not sure I have enough time for this round to talk about a sitting anti-slap to in Thai and under Thai law. Ka, Ajahn Sarinrat. Do I have enough time this round, or should I wait for next round?
You should speak next round.
Okay, ka. So I'll keep it for next round.
So thank you for the first round from Kun Sanhawan Sisot. So next, please welcome. May I invite Mr. Edmund Bon Thaisun, Head of Chamber Civil Melbourne, Malaysia, for sharing the idea and the problem of slap law in Malaysia and discuss about this topic with us today. Thank you.
Thank you very much. Thank you very much, Prince of Songkla University, ICJ, for inviting me. Just to the first question, slap suits which are designed to intimidate and to deter or threaten action and criticisms are something that is rather new in Malaysia. Known as slap, we would usually call the cases defamation cases in civil defamation cases, and the pattern of slap cases is when to call it slap is still quite new. So it's still uncommon to call some of these cases slap, but there is no shortage of frequent and numerous lawsuits filed by companies and politicians in power against human rights defenders and against civil society groups, as well as community activists in Malaysia for defamation. So typically what will happen is that there will be a pre-action letter of demand that is sent to the maker of the statement, and the demand will request that the maker of the statement, whether it's a human rights defender or a civil society group or NGO, issues a public apology and to pay compensation. Usually when the demand is refused, then there will be a suit in defamation, a civil defamation, which will be filed in court. And sometimes it will be a criminal defamation under our penal code, where a police report is lodged to the police. And depending on the nature of the statement, then the police issues a prosecution against the particular person who makes the statement. For very high profile cases, as mentioned just now by Kay, the injunctions are obtained in the civil court for what is known as an interim measure or a temporary injunction that stops the maker of the statement from repeating the statement pending the disposal of the civil court case. So if the court gives the injunction, then it means that the defendant is silenced until the end of the case. And in Malaysia, typically a case will take about 9 months, a year and more. And then we have 2 tiers of appeal. So it will go from the lower court to the higher court, and then there's an appeal court. And if you add up the years, the case continues, and until its disposal, it will take probably up to 2-3 years. And that's being very optimistic. Therefore, if the injunction continues for so long, a lot of the issues and the statement that is made will become worthless, even though the defendant or the NGO or the human rights defender in the end wins the case. Therefore, the many companies and I think government as well uses these type of tactics to silence and to use the injunction, even though they don't win their case, but it will effectively stop the defendant from raising the issue in public. That means then, as I mentioned just now, because this information is important information is perishable, means it needs to be given now and be used now by people. If it takes so many years, then really the company wins by stopping the statement from being repeated. So the statement becomes overtaken by events and no longer hold any value. In terms of Malaysia, so there are defamation cases, civil defamation cases, but and it's well known among the population, even the normal general public. Once they see a statement being made, they will say, "Oh, go to court and file for defamation." Everybody understands what is defamation, and in Malay, it's quite a bad thing to defame somebody, to say bad things about somebody. Fitnah is the Malay word, so you should not be defaming somebody. I think that's what we learn in our culture and what we grow up with. So everybody is very used to that. So it's well known, but it's only a recent phenomenon that NGOs and civil society are starting to frame some of these cases against human rights defenders as slap cases. So there has been a recent case against a company who had called out logging company. Now that case is being seen as a slap case, and when it's seen as a slap case and not just a purely defamation case, it takes on more of a different character, because it will be seen that the company that is taking action is trying to bully or harass the less powerful human rights defender who has less resources, to muzzle the expression and to stop activities of the opposition towards the company. It was just only a few days ago that some community activists, my clients, actually came and let me know that a letter of demand was sent by a company because there were some statements that were made by the community activists that was going against a factory that was building and manufacturing hazardous materials in the community. So the balance now, I think the question is the balance when we want to fight slaps. The balance is, on the one hand, the right of the company to sue for defamation, because the right to freedom of expression can be limited, and it can be limited to protect reputation. And then on the other hand, the affected stakeholders have the right to expression at the same time, to voice their concerns about the issues that affect them. So where do we draw the line, and how do we, which gives where there is that kind of competing claim? And so the law sometimes plays a part in Malaysia, as I mentioned, and I'll talk about it in the next segment regarding the way that defamation defenses have slowly started to expand. That can be used as one of the ways to defend against slap cases. I will stop there for the moment, just to explain what's been happening on the pattern of these type of cases in Malaysia. Thank you.
Okay, thank you very much for sharing the slap in Malaysia. There are many issues that interested for this seminar. So I will next would like to invite Mr. Jordan Fronda, a representative from the Philippines, from the Center for Environmental Concern, please.
Hello everyone. Thank you for introducing me. I'm Jordan from Center for Environmental Concerns Philippines, and to introduce our organization briefly, we are an environmental research non-government organization that conducts researches, and provides services to communities, primarily to help save the environment. So we have that kind of focus on the environment, communities, and environmental defenders. Philippines is a mineral-rich country, so as a background, and so we are a hotspot for destructive multinational industries and projects such as mining, logging, and plantations. Because of this, several communities have been affected and are opposed to these industries, and this resulted to resistance. And so most of the slaps that we have, at least what we have recorded, are cases against environmental defenders, so people that are defending environmental rights. Although I will be focusing on cases against environmental defenders, it is important to note that all human rights defenders experience generally the same trend of attacks as the trend experienced by environmental defenders. For example, so how environmental defenders are receive slaps. For example, a community stages a barricade, then uh, the mining company will give them slap, and so they will be forced to defend themselves. Usually at the court level, and so the barricade will be weaker, and the operations of the mining companies will become easier. Sometimes journalists, scientists, lawyers, researchers are also uh, uh, faced with slaps, and they are forced to respond to it. Um, okay. So there have been several cases of slaps in the Philippines. A notable surge can be was observed in back in 2006 to 2007, when the term slap was not yet legally defined. Uh, because of this surge, uh, the a legal remedy was forced by the people and lawmakers. Hence, the passing of the anti-slap law. I would like to share also that during this time, our former executive director was faced with slap because of conducting research and speaking against a mining company in a province here in the Philippines, which was thankfully dismissed. Nonetheless, we spent so much resources uh, facing that slap case. And so the trend, we see the trend here in the Philippines, slaps also tend to not win cases, but just take the time and resources of those who receive the cases. And so the anti-slap law was passed in, I think, 2011, which was highly beneficial to human rights defenders and environmental defenders. It provided protection against slaps. It defined slaps and it defines slaps almost similar to international definitions, and the definition stated a while earlier by Sanhawan, and it expedited dismissal of slaps, meaning those affected with slaps can quote unquote slap back against the complainants. It also increased penalties for slap plaintiffs, which is very essential because as environmental defenders and human rights defenders defend themselves against slaps, they are consuming resources. So included in these penalties were the resources and all the losses, damages that the defendant have incurred. Okay, so I think that's it for my first round. I will share the challenges and the ways forward that we see in the Philippines maybe later in the next round. Thank you.
Okay, thank you, Mr. Jordan Ronda. Then next, for the last speaker in this round, please welcome Mr. Reynaldo Sambiring, Executive Director, Indonesia Center for Environmental Law, for sharing the idea of slaps from Indonesia. Please.
Yes. Thank you, moderator, for introducing me, and thank you for Prince of Songkala University and ICG for inviting me. speakers. I'm Renaldo Sembirin, the Executive Director of Indonesian Center for Environmental Law, one of the environmental organization in Indonesia. And actually, my organization has some of the experience to promote and do the legal reform regarding the anti-SLAPPs in Indonesia since 2009. And one of the success story is to pressure the government and the parliament to put the provisions to regulate about the anti-SLAPPs provision, our Environmental Protection and Management Act 2009. Okay. Okay. Our discussion today is consists of the three big parts about the SLAPPs in Indonesia, tools to fight back, and the way forwards. However, for the first round, I'll stop about the tools to fight back. Is it right or only about the Indonesian situations? Okay, I will start again. Yeah, SLAPPs Indonesia. The first things about the SLAPPs in Indonesia, we have to know that SLAPPs in Indonesia, the form of SLAPPs in Indonesia is not only in the lawsuits, it's not only in the civil cases forms. It's included the criminal cases, and many of the SLAPPs cases in Indonesia is happen in the criminal cases instead of for the civil cases or the lawsuits. So in Indonesia, SLAPPs is the acronym of the strategic lawsuits, strategic litigations against the public participations, because it consists the litigation in the context of the lawsuit and criminal law. For the SLAPPs legal framework, we have the foundation by our Indonesian Constitution 1948, because it's mandating protection of the public participation rights and rights to good and healthy environments, and the public participations to get good and healthy environment is must to be protected, and it's the reason why Indonesian government and the parliaments are regulated about the anti-SLAPPs in our EPMA 2009. And in our EPMA 2009, actually anti-SLAPP has regulated only at the one article, at the Article 66, and the article is general. Is need to be make it as specified for our legal practice. And the other policy, is the Chief of the Supreme Court decree on guidelines for handling environmental cases, is also provide about the mechanisms anti-SLAPP in the judicial process. The next about okay, this is the sum of the numbers SLAPPs in Indonesia. I have to say the real number may be higher due to the weight rates of the criminal provision used in SLAPPs, and because we don't have the integrated data, I believe that many of SLAPP in the criminal cases happen in the remote area but have not been recorded well. For the some of the organization, we can see the high number of the SLAPPs, particularly for the criminal law. And but if we see in the court process or in the judicial process, only 6 court decisions examines anti-SLAPP provisions for 3 cases each in civil and the criminals. If you ask me about what is the roots of the causes SLAPPs in Indonesia, my answer is one of the root of the causes is about the lack of the public participations. I use here the letter of citizen participation by Einstein's, and based on our monitoring, many of the public participation in environmental decisions only at the stage of the informing, or from the several cases in the remote area, there has happened the non-participations. Just one the popular cases in North Sulawesi, the eastern part of Indonesia. one of the community, one group of the community in one island, they don't know about the license of the company, license of the corporations in their area, because it's lack of the public participations. They don't involve in the environmental decisions. They don't get the information properly, even though the location of the company is close to their village, or some of the area of the company inside of their village. That's the one of the examples. How is the lack of the public participation in environmental decisions make the public giving the protest and get the slabs because the lack of the public participation is the reason. Okay, the next point about the category of slab cases in judicial process in Indonesia. I divided as the 4 category. The first category, slabs or anti-slabs argument, only come from the parties, from the plaintiff, prosecutors, and or defendants, and there is no examined by the courts. The second category, slab argument, come from the parties and examined by the court. I think this is the best one. The third category, no slabs argument from another best one. And the fourth category, no argument about slabs by parties and by the courts. And if you ask me, it's the most of the slab cases in the criminal cases in Indonesia. So I think that's why we need the legal reform about the slabs in Indonesia. Okay, how about the pattern of the slab? It consists of 2 kinds of the pattern. The first pattern, slabs can be identified because the violation of the public participation or expression is connected to the advocacy. For the example, I as the environmental activist giving the protest about the infrastructure or development, and suddenly and then the contractor or the company bring the lawsuits or bring the report to the police, and it stopped my advocacy, it stopped my expression, it stopped our participation. So the connection about our participation and the advocacy is clear. However, the many of slab patterns in Indonesia, particularly in the criminals, are difficult to identify because slab pillars are using norms or provision with no relation to the advocacy. For example, using the communism symbol or insulting the national flag, etc. Communism symbol because communism something is prohibited in Indonesia in Indonesian law, and this is one of interesting cases. I will explain it later. How is the community their expression, their participation stopped because they reporting to the police because the police and prosecutor accused them about the insulting the national flag. It's not the relation is not clear about the provisions that accuse with the advocacy. There are some of the slab cases in Indonesia. However, I will skip that, so we have a proper time for discussions. This is one. Yes, this is the notable court decision in the criminal. This is Sawin Sukma and Nanto. I mentioned before about the insulting the national flag as a national symbol. So for these cases, actually, they celebrate because they won at the court, and then they raise our national flag, and the next day, the position is not the position of the flag is upside down. So because of that, the police and the prosecutor accused them the insulting of the national flag. It's make their advocacy, their expression stop. And this is the second one, the Robandi and friends decision cases. This is the only one cases in the criminal cases that have won by the court. Only one until right now. Only one slap in the criminal cases that have won by court in Indonesia. I think I'm stop here to explain about the Indonesian's current situation, and we will discuss later. Thank you.
Okay, thank you for sharing the topic with us. And we will move to the next round. So for the next round, we are going to discuss about what legal reforms do we need to further improve protection against slaps. Okay, so for the second round, we will start with Kun Sanhawan Jisot again for the second round. Thank you. Please.
Thank you. Before talking about legal reform, last round I didn't finish talking about existing anti-slap tools in Thailand. So in Thailand, indeed, we have certain legal frameworks that are drafted with a primary objective to fight against slap. And these laws were introduced 2 years ago. It's pretty new. There are section 161/1 in the Criminal Procedure Code and section 165/1 in the Criminal Procedure Code. In addition, there are one section in the Public Prosecution Act that is understood to be another tool to fight against slap. However, these three laws, which I will later explain in detail how this look like, they are still kind of inadequate. I will explain why they are kind of still inadequate in order to fight against slap in the countries. So the first one, Article 161/1, is basically allow an early dismissal by the court if the court, if it appears to the court that the complainant or the plaintiff has filed the lawsuit in bad faith or distort fact in order to harass the defendant. We have to highlight that this section of the law only apply to private complainants. And when I say private complainants, that means it's only applied to the case that was submitted directly, the criminal case that was submitted directly to the court. It's not applied to the case that go through a police channel. It's not applied to civil cases. So this is one limitation. Another section of the law is Article 165/2. This one is allowing defendant doing preliminary hearing to submit and test evidence to demonstrate that the case lack merits. In the past, in Thailand, if you bring the criminal case directly to the court, again, not through police channel, it's not civil case, if you bring the case directly to the court, then there will be a process that called preliminary hearings. And during these hearings, in the past, only plaintiffs have a lot of chance and power to present the evidence to support their arguments. So the court may judge that whether the case have merits to proceed the full trial or not. So the law amended to provide an opportunity to the defendants to always submit some evidence during this process as well. So if it's slap cases, so the case can be dismissed very early on. So this sounds like a very promising step that has been made by Thailand. And indeed, I think they have a very good intention of introducing these two laws, and it sounds good. However, when we really implement it, we found several problems. First, like in Article 161/1, because the law failed to articulate the definition of bad faith. So normally when the term is pretty broad, like bad faith, then judges kind of hesitate to exercise their power under this law because the term is too broad. They are not sure what kind of case will fall under the definition of bad faith. Is it what kind of case will be slap cases? So they still have no idea. So that's one problem. And also, in some countries, when it comes to slap cases, the way they wrote in the law, they explicitly protect the free exercise of human rights and fundamental freedoms, instead of saying that the case that filed in bad faith, the court should have the power to dismiss it. Some countries say that if the case was filed by the defendant exercising their human rights or fundamental freedoms, the judge can dismiss a case. That indeed, if it right that way, it could be a little bit easier for Thai judge to look into the issues and judges about how they whether they should dismiss that case or not. The second concern is that it also allows the case to be adjudicated entirely up to the judge's discretion. Under 161/1, if the case submitted to court, the judge can say everything. They don't even need to call for parties to submit evidence to support their arguments. The court can just decide it. But indeed, for us, the perfect model could be that both parties should be allowed to have the right to submit the evidence to support their claims. The third one is, I already said that both provisions is only limited to private criminal complainants, which means the case is submitted directly to the court. It's not the one that linked with the police or public prosecutor, and is also not applied to civil cases. And we try to monitor the application of these provisions of the law, and we found that the court hesitate to apply these provisions. In some cases, in many SLAPP cases, the lawyer were the one who submit requests to the court to exercise their power under these provisions. In some cases, the court just ignore it. Sometimes they acknowledge the receipt and then they ignore it. Or sometimes they're looking into the request, but they're deciding that this is not, they're not going to dismiss it because they are not sure of the intention of the plaintiff. They're not sure whether it's SLAPP or not. So that's still a problem in reality. Another one is Section 21st of Public Prosecution Act. It's equip public prosecutor with certain power to dismiss the case if they find that there's no use to the general public. Like if you prosecuted the case, there's gonna be no benefit to the general public, you can dismiss it. However, there's problem about this law. It is very time consuming because the only person who can exercise this power is the Attorney General. It's one person. So if any public prosecutor thought that this is that case, they have to forward the case to Attorney General and they have to wait. So this is not helping SLAPP because people have to wait for years again, just for Attorney General to make a decision. And indeed, it's a little bit weird when the public prosecutor want to exercise power under this provision of the law, because public prosecutor also have their ordinary power to just dismiss the case. They can say that there's no merit, or they can say that the defendants indeed exercise their rights under Constitution, and they just exercise their human rights and fundamental freedoms. But they rarely do that. We just found that there are one cases that the public prosecutor would stand up and say, no, it's SLAPP cases. The victim exercising their power under the exercising their rights under Constitution. It was just one case in Southern Thailand that public prosecutor said so. So I will end my presentation with this one. Just to sum it up, because we have a lot of problem with the current legal framework, the existing legal frameworks. I mean, it's a good initiative, but it needs to polish a little bit to make it more effective in order to fight against SLAPP in the countries. So of course, first we have to ensure that there will be an effective early dismissal mechanisms. We have 161/1, but there are some gaps within that law. So we need to collect to fill in the gaps and make this early dismissal mechanism work. Another thing is that we have to address the problem of now the trial in Thailand is very slow. It takes years for court to reach the decisions, but trial should be prompt and speedy, otherwise the defendant will be under a lot of burden. So that's another thing that needs to be reformed as well. Also, the court should be empowered with more power to provide safeguard during trial proceedings in case that they found out this is a SLAPP cases. For example, they could be able to suspend the proceeding if they have the reason to believe that it's SLAPP cases. Next one, I think that's happened in the Philippines. They should be the court should permit recovery of costs by SLAPP target. So SLAPP target should be able to to fight the lawsuit to take an action that you call SLAPP back, against those who initiate SLAPP lawsuit against them. There should be penalties on those who are SLAPP initiator as well. And lastly, but very important, is that it's not just about reforming anti-SLAPP law, but we also need to reform the cause of actions that commonly form the basic of SLAPP. Like in Thailand, we need to amend those non-human rights complaints law and also decriminalize defamation, so they are not used as a basic for SLAPP in the countries. So I end my presentations here.
Okay, thank you, Kun San Hawan Sisot. So next, please welcome again Mr. Edmund Bon Thaisun for the second round, please.
Thank you very much. Having said just now that SLAPP is not a separate genre of cases, unlike how there's anti-SLAPP legislation in California, Thailand, Philippines, and Indonesia in different ways. So the defendant is left with relying on, in Malaysia, the common law defenses to defamation, and also to relying on statutory defenses to defamation under our Defamation Act. So our common law relies very heavily on how the judges interpret the cases based on past judicial precedent, and that has flowed down from how the United Kingdom has applied the defenses in Defamation Act for defamation cases. So the most common defenses and what we would say in law, the tools to fight against SLAPP would be the defenses of what is called qualified privilege and fair comment. Occasionally, we will be using justification or truth as a third form of a defense. So for the defense of qualified privilege or QP, the defendant must show that the words or statements were made and uttered on a matter of public interest, number one. And number two, that the defendant, meaning the group, NGO or the human rights defender, acted reasonably or responsibly to publishing the same. And then what the court will do is that the court needs to look into several factors and consider whether the defendant had acted reasonably and responsibly. These factors would include how serious the allegation is, what is the type of information and the extent of the information that is of grave public concern, the source of the information, steps that have been taken to verify the accuracy of the information, how urgent is the matter, whether the plaintiff side of the story, means the company side of the story, has been sought, and what does it disclose, and if so, what does it say, and the tone and timing of the publication. So once the defendant can show these factors in his favor or her favor and meet the two tests by the common law as interpreted by the judges, then the issue will be determined in favor of the defendant, even if the words are untrue or even if the words are defamatory of the plaintiff. So that qualified privilege defense is resting on public policy of convenience and of protecting free speech, that law will allow on certain occasions an individual to make statements which are defamatory and untrue without incurring any legal liability. And that principle has always applied throughout in Malaysia. The second common defense is the defense of fair comment. And the words that need to be shown must be it must be a comment made by the defendant, not just statements of fact. Number two, the comments must be based on facts that have to be proven to be true. Number three, the comments must be fair. And number four, the comments must be made in a matter of public interest or public importance. So if it's just a comment on a private matter, that would not count. However, what is good is that the defense of fair comment does not fail only because all the truth of the allegation of facts is not proof. So under Section 9 of Malaysia's Defamation Act, it is not essential that all facts have to be proved to be true. And it is sufficient if the facts which form the basis of the comments are proven to be true, then you will succeed on the defense. But for both the defenses of qualified privilege and fair comment, if the company is able to show that there was ill will or malice on the part of the maker of the statement, then the defenses will not succeed, it will fail. And then finally, I just wanted to share on the defense of justification. So the defense of justification or truth, the defendant needs to show, of course, that the statements they made, he or she made are true or substantially true. And even if you cannot show that they are true or substantially true, the defendant can still justify the statement based on his or her understanding of the meaning of the statement, which may be different from what the plaintiff means the statement to be. So you can, when doing a justification defense, you can say, I actually mean B, and justify B when the plaintiff is actually suing you, saying that saying that the plaintiff understands the statement to mean A, so that you can shift the meaning of the defense depending on how you want to make the statement and what you mean in the statement. If you can show that, then you can succeed on the justification. Just quickly as to the legal reforms that I would like to see is, for Malaysia, as you can tell, there is really no anti-SLAPP legislation at all. And therefore, even to take the first step for government to have law reform to clarify the legal position on how SLAPP suits are defined, to recognize SLAPP suits, and to look at what type of lawsuits are considered SLAPP cases. That law should be put in place so that the judges are able to say, okay, this case was filed to harass, threaten, and silence humorous defenders, and therefore it's a SLAPP suit. At the moment, the judges are not able to say that because we have no such legislation. The second recommendation is that there should be regulation or law prohibiting the certain categories of persons like public officials, public authorities, government officials, politicians. Local authorities, they should not be allowed to sue. And that is the position in the United Kingdom in the case of Derbyshire. But I think in Malaysia, we have not recognized it, and there should be a law that prohibits these categories of persons from suing. Number three, of course, the often repeated statement is to have greater freedom of information, and in Malaysia, it's due time that the Freedom of Information Law has to be put in place to allow residents, communities, activists to access information that will affect them. A lot of times, SLAPP cases come about because when projects are undertaken, there's large information gaps that handicap the affected stakeholders from properly assessing the projects. So then the defamation happens because the plaintiff or the company takes advantage of these information black holes and say that the maker of the statement is wrong or the statement is untrue because the plaintiff has information that has not been shared to the defendant. So when the defendant or the group makes a statement, they have to guess sometimes what has happened or what will happen. So that information black hole needs to be filled. Number 4, Malaysia's Defamation Act 1957 has to be amended. It is an act that came into force when we were independent. It should broaden the types of defenses available and make them consistent with the common law in Malaysia. Number 5, the recommendation is to make it mandatory for companies to have open, transparent, accessible, external grievance mechanisms with mandatory guidelines and regulations to be followed, so that these mechanisms become the first port of call and allow an avenue for engagement between parties so that SLAPP suits become the last resort. And number 6, my 6th suggestion is that there's a new defense of reportage that has been recognized in Malaysia, where you can repeat certain statements even though they are untrue, so long as you don't make them your own. And that has been recognized by our federal court, but it's not recognized in legislation yet. So for clarity, that should be should be legislated and allow for statements made in the public interest, even though the statements are untrue. And my last recommendation is similarly with Thailand. Criminal defamation in Malaysia is an offense that someone can be jailed. So it's time to decriminalize that offense in Malaysia. Thank you.
Okay, thank you for Mr. Esmond. There are many very good recommendations to deal with the SLAPP in Malaysia. So let's move to the Philippines. Please welcome again Mr. Jordan Fronda from the Philippines to mention more about the SLAPP, how to deal with the SLAPP issue in the Philippines. Thank you.
Okay. So I will continue my presentation a while ago. Moving on to the challenges with regards to facing SLAPPs in the Philippines. One of the challenges we have seen was constraints on information and socioeconomic status of environmental and human rights defenders. What I mean by this is if we see the situation and the backgrounds of these defenders, most of them are the simple folk, as they say, the fisher folk, farmers, indigenous peoples, those living in the countrysides where electricity, education, and other basic services are very few. So they are rarely reached by those. And so information like the presence or the availability of legal mechanisms against SLAPPs is most of the time not known to them. So they usually don't know that. And also the socioeconomic constraints, most of the time those faced with slaps are having a hard time taking out utilizing resources because they have very few in the first place. So I think this is not okay. So that's one challenge, these types of constraints. And we also surmise that there is an underreporting of cases in the Philippines. And I think uh, other presenters a while ago also uh, observed this in their countries. So I think this is present also in the Philippines. Specific to us, I think this is because it is hard to follow the local cases of slaps, and they are also usually not broadcasted in the news. They are not captured in the news because there are more uh, quote unquote newsworthier uh, events such as the killings of human rights defenders like that. So we are having a hard time recording, and they are having a hard time reporting cases of slaps. These two other challenges are quite not a direct, not very direct pertaining to slaps, but they heavily affect slaps and the advocacies of human rights defenders. One is the Anti-Terrorism Law, which uh, uh, considers critics, criticisms, and those who speak out, the activists. It considers them criminals based on vague definitions. They are considered terrorists or communists under this law, and it is seen to be worse. It has seemed to be worse and have caused worse conditions for rights defenders since its passing last year. And it also enabled more and more aggressive other human rights violations, such as these stated here: threat intimidation, illegal arrest and detention, displacement, red tagging, and killings, which is also favorable to those usual complainants of slaps. In the Philippines, in the case of Philippines, the destructive industries such as mining and the others. So stemming from these challenges, we have our recommendations to improve and increase protection for rights defenders include enabling the defenders to make use of legal remedies and to defend themselves. So this can be done through increased legal assistance. I think this is the most related to legal reforms in our recommendations. Increasing legal assistance, I mean the national funding, so that more lawyers can will be available for human rights defenders, especially to those who are relatively lacking in education, in resources, and through economic reforms. So this could be uh, attained by that. Because having a anti-slap law haven't ensured the safety of rights defenders and haven't ensured them that they can continue their advocacies for the environment and human rights. So as I have said earlier, there are also other threats such as intimidation, killings, arrests, and others. And also the junking of policies against dissenters and critics, such as the Anti-Terrorism Law. Actually, in the Philippines and in our records, we have more records of killings and other abuses, and relatively fewer slap cases, because I think this have been the other methods of quelling resistance and activists have been more convenient for the perpetrators. For example, if you kill a defender or you illegally arrest them, they are stopped from doing what they are doing, and it's in favor of the large industries. So I think to end my presentation, as a lawyer have said in the Philippines, what is the use of protection from slaps if the client is dead after a day, a week, or a month. So I think that's my point in this last recommendation. That's all from me. Thank you very much.
Thank you, Mr. Jordan from the Philippines. So may I announce that if anyone would like to leave the questions, that leave the question to the chat, and then or in every way that you can connect with us, so I can provide those questions to share, to discuss with the speakers. Okay, for the last for the last
for the last speakers.
Okay. Okay, for the last speaker, please welcome Mr. Reynaldo Sembring, a public lawyer, the Regional Council of Walhi, Jakarta, again, and to share the topic, the tools to deal with the slap issue from Jakarta. Please.
Yes, thank you, Mr. Surin Roots, Mr. Moderators. Actually, I am the Executive Director of ICEL, Indonesia Center for Environmental Law, and Head of Supervisory Body of the Press of the Earth International Indonesia. It means the Walhi Nationals. Okay, I will continue my presentations. These are tools to fight back and utilizing the existing norms. As I mentioned before, Indonesia, we have the constitutional rights, human rights provisions. It's the challenge to explain that anti-slaps is not only specific for environmental matters, environmental issue, but also it can use for any human rights cases in Indonesia. We have Article 66 and in our Environmental Protection and Management Act. The norms is very general. Every person struggling for a right to a good and healthy environment may not be charged with criminal or civil offenses. And we have another policy by the Chief Justice Supreme Court's decree. What are the challenges? The first is problem identified on Article 66 at our EPMA 2009. If you see the elucidation of the Article 66 EPMA, the protection of the anti-slaps is limited only for the community or groups or the peoples who bring the lawsuit or giving the report first and then get the slaps. So if you only the participates in the environmental decision, for the examples, the anti-slaps provision is not works because our EPMA at the elucidations, it stated that unlimited, I think it's the mistakes interpretation is the mistake of elucidations, but it needs to be clear by the derivative regulations, because the elucidation is make the limitations of the anti-slap only if the slap fillers has failed the lawsuits or the reported by the criminal law. The other issue is about, and the other challenge is about the existing mechanism on our Supreme Court's decree, because it's insufficient to effectively implement the anti-SLAPPs. Why? Because the Supreme Court's, the Chief of Supreme Court decree is not the part of the regulations. It's only the policy, internal policy by the Supreme Court. So it's difficult to make or to reform the procedural law by the Chief of Supreme Court decisions. So that's the one point. And the second point, at the Chief of Supreme Court decree is not provided about the earlier dismissal process or speedy trial before the trial to prove the evidence sessions. Okay, the next point. The next point is insufficient preventive mechanism in our criminal procedure act. As I mentioned before, SLAPPs in Indonesia many happen in criminal cases. However, our criminal procedural act is not properly giving the preventive mechanisms in the investigation process or in the pre-adjudication process to stop the SLAPPs, because the provision is not clear and is not, and so that's why we need to revise that. And I think the other issue is about the lack of the protection on the public participations, because for the many government institutions or for many legal enforcers, SLAPPs is only about the scope of the SLAPPs is only for the environmental issues, is not for the any and human rights cases. So I think that's the issue that we need to be solved. The other issue is the lack of knowledge on law enforcement regarding anti-SLAPPs. That's the point that I explained before. I think this is these are some of the idea to fight back, but about the extra legals beyond the law, to capacity, giving the capacity building for the public defender and civil society, delivering the amicus curiae brief with the anti-SLAPP argument. Actually, the amicus curiae brief is not official in our judicial process. However, we have some of the successful case that the court giving the considers and examine our amicus curiae brief. So giving many amicus curiae brief can help the court understand earlier and faster about the anti-SLAPP and make the strong public campaign and media engagement. And the ways forward or the reform agenda. The first point is issuing the implementing regulation on Article 66 under our Environmental Protection and Management Act. We need the more comprehensive provisions. It consists the three things. The first thing is the official definition of SLAPPs or anti-SLAPPs in Indonesia, because until right now we don't have the official definition about the SLAPPs or anti-SLAPPs. The second thing is about the criteria to assess the SLAPP cases. It's important, and I think it's the part of the derivative regulation under the Article 66. And the last things is about the subject that can be protected by the anti-SLAPP mechanisms. So who can be protected by the anti-SLAPP? It's only the people, it's the community or the group, NGOs, or it's including the government. I think that's the questions that need to be solved in our derivative regulation under the Article 66. The next legal reform, the second one, is revising our criminal procedure act. In the latest draft of the criminal procedure act, recognize it about the investigative judge. investigative judge that is the opportunity to ensure slap cases are dismissed on earlier stage. I mean, for the criminal law process, when the police need to arrest, for the example, need to arrest somebody, so they need to get the permit first from the investigative judge. So it's make the authority of the investigator or the police limited, so it can prevent the slap cases, the number of the slap cases in Indonesia. My third point is issuing the Supreme Court regulations, because since I explained before, because our Chief of Supreme Court decree is very limited and is not part of the regulations. It's only the internal policy. So we need the Supreme Court regulations to provide the clear mechanism to assess the anti-slap and to provide speedy trial mechanisms to halt the slap earlier, like previous speaker say, to make the effectively earlier dismissal mechanism. We need it at our Supreme Court regulations. My fourth point, enacting public participation act, I think is the important things, because in my opinion, the root of causes about the slaps in Indonesia is the lack of the public participations and the lack of the public informations by the company or by governments. So right now we need the Public Participation Act to ensure the full protection, to ensure the rights for the public to participate in the environmental decision, in any decision, and in the regulation process, and to ensure full protections when they participate, is including the anti-slap. And this scope of the Public Participation Act not limited to environmental issue, is broader than environmental issue. It can happen in the agrarian issue and or the others, in the housing issue, in the consumer, or in other sectors. The last point is the capacity building for law enforcers, civil society, and public defender. Even though we don't have the strong regulation about the anti-slap, at least we have our constitutions. At least we have our EPMA, that our Environmental Protection and Management Act, that provided the articles, even though it's only the general articles, but it's provided the Article 66 about the anti-slaps. During this process, during the reform agenda, we need to improve the capacity, our law enforcement, civil society, and public defender for using anti-slaps mechanism. And I think it's the one of the strategy to make it happen and to make it faster implement in Indonesia legal system. I'm stop here. Thank you. Pardon, I think you are mute. Your voice is mute.
Okay, sorry. Thank you, Mr. Reynaldo, for sharing the idea with us. So let's move to the next session, Q&A session. So some participants sent me a question to ask the speaker about some topic. So the first question is, there is a case in Thailand that if some normal people or employee criticize other people who is very rich, who like will be do the big projects, and then they criticize online, comment online, but those people who who would like to use a tactic of area, like if in Thailand we can, if they report those, they report to another area, like the people who comment in the south of Thailand in Hat Yai, but they report to the police in Bangkok or in Chiang Mai. So it's kind of slap law in our country. So how we can deal with this issue in your country? You know, it's about online issue, and then the people who are report to the police need to go to, like, from Hat Yai to Chiang Mai or to Bangkok. So this is very difficult for them to deal with this problem. So may I ask Kun Sanhawan Sisot, what is your opinion for this, for deal with this issue?
I mean that, well, I can share from Thailand perspective, but probably some other speaker can also share about.
Okay.
I mean, if I'm not sure whether that's happened in other countries or not, and if it happened, then what was your resolutions? But for me, I mean, for Thailand, indeed, when the law was enacted, the anti-SLAPP law in Thailand, the one who enacted the law was the court, Thailand Court of Justice, and they gave an example of what they consider as SLAPP cases. And the first cases that they provide as an example was the case that people sue, you know, the defendants, the victim, in the area or in the province that far from their residential area. Like they deliberately force them to travel many hours just to report the police. So in theory, this is the SLAPP case that the anti-SLAPP law, especially section 161/1, should apply. However, I understand that the case that you're talking about is one of the biggest gap of 161/1, because 161/1 only apply to the case that brought directly to court, not apply to case that go through police channel. So one thing that we very niche is, first, on the legal framework, we need to amend the legal framework. At least we need to amend 161/1 to make it cover the case that brought through police channel and also civil cases. That's one thing. And second thing is that we need to raise awareness of police officers. You know, police officers have no idea about SLAPP. They have no idea about 161/1. More judges know about SLAPP than police. So if police know about this, you know, you probably don't have to worry, because they will be able to use their ordinary power to dismiss the case, saying this is SLAPP cases, because Thailand Court of State, which is a very, you know, big organization of judges, already say that this is an example of SLAPP. So, well, my recommendation is two things. We need to to amend our legal frameworks, and secondly, we need to raise awareness of those in justice sector actor. But this is clearly a SLAPP cases according to Thailand Court of Justice. And probably some speakers from other countries have experience. I'm not sure whether this happened in other countries or not.
So maybe just only Thailand issue. Okay, so do you have any recommend to Thai issue? Okay, so maybe we need to deal with this issue by ourselves. Okay, for the next question, sorry for Kun Chan Hawan again. The question is, as a participant from Thailand, I would like to know the opinion of the Thai expert, which laws or mechanism in the other countries in this issue can be applied to the revision of the Thai laws relating to anti-SLAPP in your opinion?
Yeah. Please correct me if I'm wrong, but I think one interesting model is the Philippines, because the problem with Thailand right now is that the judges hesitate to use anti-SLAPP law because they are not sure whether this is SLAPP cases or not. But in the Philippines, there are efforts to define, SLAPP by several stakeholders, So I think this could fill in the gaps, so judges could know that, oh, okay, so they have some guideline that, oh, this is SLAPP, and they may use it. I mean, they can probably dismiss the case based on the fact that it's SLAPP case, and they have more confidence to do so. And you have the process of SLAPP backs. I mean, it's pretty clear SLAPP backs. And it sounds like in the Philippines, SLAPP is like kind of like something that is that many people in justice sector are aware of. But I mean, Jordan, you may correct me if I'm wrong, but it sounds like many people in the Philippines know about SLAPP. Another model is probably in the US, because US is the origin of anti-SLAPP law. So when we talk about early dismissal mechanisms, many laws are in the US, and they try to define it different way, depend on the state, which state that we are in the US that we are talking about. And they also provide quite a high level of protection of the victim, the SLAPP victim, during the trial process as well. But yeah, I mean, if Philippines want to add something or correct me about this.
Do you have any more opinion for us, Mr. Jordan?
Hello.
Do you want to share something?
I will share something. Yes. In relation to what Sanhawan said. In the Philippines, legally, relative to other countries, I think I can say that SLAPP is more defined and more popular in the legal field. But as I said earlier, the challenge remains most of those affected by SLAPPs are relatively undereducated or at times illiterate. And so it remains as the challenge in the Philippines. But the mechanisms, I think, would be relatively advanced. They are there, but the challenge is how can we enable the rights defenders to use this mechanism. And I would also like to share that as with most legal cases, there is always the risk in the anti-SLAPP law in the Philippines does not ensure that if you think it is SLAPP, the rights defender will win. The rights defender still has the burden to prove that the case is a SLAPP. Then he or she could slap back, then the the initiator of the slap can also disprove the claim that the case is not is a slap. And there are many factors in that process. So how strong the evidences are, and most of the time, corruption also uh, is in the play. Most of industries have backers in the government, and most government officials, especially those in the higher positions, are either related to the destructive industries or funded in their election campaigns by these industries. So there are a lot of challenges still, even though in the legal aspect, slap is banned, and that's it, I think.
Thank you, Mr. Jordan. Do you um, um, for may I have other comments from Mr. Edmund Bontai-Sun about this issue to deal with the slap law in Thailand?
I have to say that I don't know enough about what's happening in Thailand in terms of the advocacy, but the promising laws that have been put in place, I think a good step. But of course, in the way they are implemented and the interpretation of how slap suit is to be is still a huge challenge. And as I was just listening to all of you and learning from the Thai, Philippines, and Indonesian experience, and thinking how we can do it in Malaysia, the question that keeps arising is how do you define what a slap suit is, considering that the plaintiff also has, or the company also has the right to take legal action in court. In terms of the issue of digital advocacy and freedom of expression, I think there was a question on something to do with multimedia and the computer crimes. I forgot to mention that in Malaysia, it is a criminal offense to use the internet and to send messages or abusive online content to people. But that really was first legislated to deal with online sales and marketing products. But in Malaysia, it's been abused. The section is Section 233 of the Communications and Multimedia Act. It's been abused many, many times, and many people have been charged and investigated under this Communications and Multimedia Act for running campaigns, running human rights campaigns, and then they have been accused of using the internet to send abusive messages. So it's why I say it's because it's comes down to the same problem of how judges are going to interpret whether something, whether a slap suit or whether an online message or online campaign is something that amounts to abuse or harassment. And it's very subjective if in Malaysia, it's not properly defined. Over to you. Thank you.
Okay, thank you very much for your sharing. Okay, there is another question about the slap law. Could each country share with us the current trend of public awareness on slap issue compared to the past? Could you each country share with us the current trend of public awareness on SLAP issue compared to the past, please? So let's start with the Philippines.
Okay.
Okay, Indonesia. It's okay.
It's okay. Reynaldo, you go first.
Oh, okay. Thank you. Yeah.
Sorry.
The following the previous question, I think same like the previous speakers from the Malaysia. I don't know very well about the what happened in the Thailand. However, based on the Indonesian experience, SLAP must be stopped earlier since the investigation process or the prosecution process, because the idea of the anti-SLAP is to guarantee, is to protecting the public expression and public participations. And if since the investigations and the prosecution process that can halt or can reduce or can silencing the public participation and expressions, the SLAPs is worthwhile. So it's important to make it stop earlier. And the other information that I know, I think 2 or 1 month ago, the court, some of the justice in the Southeast Asian country has joined the ASEAN Judicial Workshop that hosted by the Indonesian Supreme Court. That's the one topic that they are discussed is about the anti-SLAPs. So I think that's the one information that perhaps we can use it as our advocacy information and our advocacy strategy. And for the next questions, the current trend of the public awareness on SLAPs issue compared to the past. Actually, in Indonesia, SLAPs is not only for the criminal. It's not. I need to charge my laptop. Okay, in Indonesia, actually, SLAP is not for in the environmental issue, but also in the broader issue. And the trend right now, so many public aware about the SLAP. However, they more aware about the term is the criminalizations, because the criminalizations is the famous terms in Indonesia, because it's not the legal official terms, but it's like the public campaign to show that if the public or the community groups raise the issue about the public interest concerns, so they it's possible to get to get in the criminal process by the police officer or by the prosecutors. Right now, situation Indonesia more public aware about SLAPs, and the task of the NGO is to make it to make the anti-SLAPs issue, anti-SLAPs mechanism right now is broader from the environmental issue or for the environmental law to all sectors that connected with the public interest issue. Thank you.
Okay, thank you. So for the Philippines, please.
I would say that the awareness of the public in the Philippines on SLAPs has improved. So it has increased from let's say 10 years before. But in the recent events, I think the most recent SLAP excuse me, in the Philippines was the case against a media outfit called Rappler. And we have seen in that case that the cases, the slap cases against the the media outfit was very well packaged that the public did not even realize that it was a slap. So it was well packaged that the media outfit has a violation on its previous years of reporting, like that. But uh, most uh, rights defenders, freedom of speech advocates have seen it as an attack on media because the media outfit was reporting uh, everything, biased or not, for the government. And so it has also reported things that the government does not like. So it was so they were penalized. They lost the case, and the public bought it. So what I observed from that was, even though most people were aware of slaps, uh, slaps are usually well disguised in the Philippines. So uh, slaps are not always detected, uh, uh, so to speak. That's it.
Thank you, Mr. Jordan. So for the Malaysia, please, Mr. Edmund.
Yeah, I mentioned earlier that when we talk about slap, the recognition in Malaysia, because it's not a legal concept, so the awareness and the public understanding of a slap case is still quite low. They would see that everyone has a right to file a defamation case and make a complaint of criminal defamation when it's necessary, or they feel that they are hurt about it. So the increasing use of the term slap and the recognition that it will stop public activity and harass human rights defenders, there's still a lot of room that needs to for it to grow. It's only starting, I think, the past few years to become a bit more popular and to use the term, to normalize the term in society. I think the question of trying to accelerate the understanding of slap issue would progress faster if there was some sort of legal amendments to recognize that kind of frivolous lawsuit. Thank you.
Okay, thank you. And for the last one, Kun San Hawan, please.
Indeed, I think in Thailand in the past, no one has any idea about slap, but now people know more about slap, but probably not under the name of slap, and it's because of the protest movement. Because now there's a lot of political activists and protest leaders who are charged under many different laws. Though there are some civil society activists as well who are charged under the law, like emergency degree to control the COVID-19 pandemic. However, they were arrested, discriminately because there are some other groups who also protest on some other things, but they were not arrested. But this group were arrested simply for exercising their freedom of assembly, for example. So people start to question about this. They feel like the laws are, weaponizing. It's like there a trend of weaponization of laws by the Thai authorities. So they start to question about this. But indeed, this is kind of like a slap. So I think there's more and more awareness, but people might not know it under the name of SLAP, but of course there are, but I think there's more and more people who start to call it SLAP.
Okay, so it will be time's up soon. So lastly, on behalf of Faculty of Law, I would like to thank you, key speakers, participants who watching through Facebook Live or YouTube Live, and from the page of Faculty of Law, Prince of Songkhla University. And this event will not be happened if we don't have kindly support from Law Thai Foundation, Amnesty International Thailand, International Commission of Jurists, Cross Culture Foundation, Community Resource Center Foundation, and Law Long Beach. And I would like to thank you, Kun Yasasipa Suksai, for the Thai translation today as well. And thank you very much for the key speakers. So before we leaving, we need to do the important thing, is the group photo online. Please open there and make more beautiful and more handsome, or take a photo capture. Okay. One. Oh, no, not ready. One, two, three, smile. Thank you very much. Thank you. Thank you for everyone. Thank you. Bye-bye.
Thank
Thank
you.
you. See you later. Bye.
Bye-bye. Bye-bye.